Shumkhukhu. In the house of the NPA. Shumkhukhu. Ladies and gentlemen, please don't forget to hit the like buttons, subscribe, and also notification buttons, hit them and follow. Most importantly, please send us super thanks. Ladies and gentlemen, I'm trying to avoid to use the word state in this matter of the Senzo Murder Trial, whereby the prosecution is led by Baloyi and Sibanda. I know in court papers is state versus Sibia and others. However, we must be aware that it is the National Prosecution Authority that lead the prosecution. And in the state, there are those good people, ladies and gentlemen. There are those good employees and officials, including the courts. Remember, even the courts are regarded as the state because are being paid by the state. For example, the Minister of Justice, Constitutional Development, and Correctional Services is a hard worker, ladies and gentlemen. We must accept that. And is trying by all means to do things orderly so. And to a certain extent, including the courts. And I would like to apologize again for the issue of the network infrastructure, ladies and gentlemen. So, in this instance, we must be specific. The NPA's house is on fire because of the tactics and bad planning or moves by the prosecution team. If we can recall, ladies and gentlemen, with due respect to anyone, there's no intruder in my nostrils. If you can recall, previously I did mention that the defense must at all times object to whatever the state is bringing to them unfairly. If the state has new documents or exhibits, first thing they're supposed to do, they must discuss that with the defense team to say, I have this kind of exhibits or evidence. I could like to lead it in court, but I never disclosed to you at the beginning of the trial. Therefore, I would like to hear what your take in that regard. If the defense must firstly look at the document and apply their minds, then take the instructions from the clients. But first thing, the defense must at all times protect the rights of their clients. Then the first thing to do is to object. Because it will be unprocedural whilst in the middle of the trial, the state is busy investigating. Then if the defense comes to the conclusion that no, we're not agreeing with you to present this because this is unprocedural and it will render the trial unfair, ladies and gentlemen. And then the state might proceed to present that evidence in court. And the defense therefore must object and even inform the court that we did have a meeting with the state and we told them that this move by the state will render the trial unfair. At some instances, the court will hear that evidence. Okay, ladies and gentlemen, even though it is unfair and unprocedural for the state to continue investigating whilst the matter is in the middle of the trial. Then at the end of the day, the court will make a decision, a ruling, when looking at all this evidence, whether this new evidence, it has any impact it has any impact on the case. Good morning. Did I miss or it was not started? No sound. Dimagazo, can you hear me? Is there any sound? 1, 2, 1, 2, 1, 2, come in. Dimagazo Lamini, come in. 1, 2. So the state, thank you, Skills DJ. The state, it has a duty to the court and to everyone to be fair in its proceedings. To be fair when conducting the matter. Mapingi Ngwenya, thank you. So the state need to be fair at all times when conducting a trial. And it is the duty of the court to weigh the pros and cons, to weigh whether the manner in which the state conduct itself, it renders the trial unfair. Because if you can remember very well, we all knew, most of us knew about this R versus Hepworth 1928 case from the Honourable Judge, from the Honourable Court, to say the Honourable Court cannot just sit and watch. The Honourable Court is not a referee. The Honourable Court is allowed to ask clarity-seeking questions, and the Honourable Court is allowed to protect the integrity of the proceedings and the fairness thereof. And the Honourable Court must at all times, if not at certain times, to stop one of the parties taking advantage of the lack of knowledge or oversight of the other party. State versus, R versus Hepworth, ladies and gentlemen, is a classical case, okay, of 1928, which was in the midst of apartheid. But this case, it fits well in the present constitution of the Republic of South Africa. And thereafter, there are other cases that cited R versus Hepworth after 1994. Even in certain instances, ladies and gentlemen, even when the accused are represented, and in the event that the defense overlook certain issues which are very important to protect the rights of the accused, the court can come into assistance. Remember, the rights of the defense attorneys are not at stake here. They are the rights of the accused. Remember, once day I did say, in each and every profession or system, there are good and bad people. So, in the event that there are those bad people in the defense team and in some way or the other agree with the state to overlook certain things, it is the duty of the court to come to the rescue of the accused, because it is not the defense lawyers who are at trial here. It is the accused. So it is very important to make sure that the court at all times guard against the violation of the accused rights. Remember, as per R versus Hepworth, justice must not only justice must not only be done. That's very important. Justice must not only be done, but it must also be seen to be done. Okay, Bonkeile, Kriko, I'm 3 years into college and I'm a 3 lectures behind this. There is a guy named Colin. He said that he wants to be mine. I don't know what you mean by that. Okay, Dimakato Dlamini, I'm happy that you can hear me. So, ladies and gentlemen, again, if you can recall, on previous occasions, I did raise the issue of who is the enemy of the state. And I dealt with the issues of underground operations, under surface operations, like when we are on top of the ground, where above the surface, there are those people under the surface who make certain operations, who live under surface. Like what happened again in the city of Johannesburg, which is now turning out to be a umkhukhu. Wow, shumkhukhu. There was fire under the ground because of explosions and maybe cutting of certain cables, which of course, ladies and gentlemen, they affect the infrastructure. Even the network infrastructure is being affected. Is the duty of the citizens, of the law-abiding citizens, to protect the infrastructure of the country. Is the duty of law-abiding citizens to come to party and work with the enforcement agencies. Ladies and gentlemen, we are not saying members of the public must take the law into their own hands. I'm saying members of the public must protect the infrastructure around them, because they are the ones who must use that infrastructure. The law-abiding citizens must report any vandalism, criminal activities happening around them and underneath the surface. The law-abiding citizens must not at all times overlook the damage of infrastructure, because that is tantamount to sabotage. And if a law-abiding citizen overlooks such criminal activities, they might end up being charged themselves, because they should have known by most of the time that this thing is happening. They might be charged in terms of the Prevention of Organized Crime Act and Combating of Criminal Activities Act. So you must be able to draw the line between reporting, putting your life at risk, and not taking the law into your hands. Because sometimes when you report, you might put your own life at risk. I here call upon the Minister of Police to bring back 10-111, and members of the public must not be charged when reporting sabotage, criminal activities happening in our country. Members of the public must not be asked silly questions. Where do you stay? Whom do you see? What do you mean when you say they commit a crime? What's your name? Reporting on 10-111 it was meant to be anonymous. And it was meant to be straight and forward, and no funny questions must be asked. Are you sure that they are the ones? Are you sure that they are committing a crime? How long is that has been happening? You see, this kind of questions, how long you think this thing has been happening? They are putting you at the spot. Then the next question is, if you say it has been happening for 3 years, now what makes you to report it now? Why you didn't report it 3 years ago? So it put you in a dilemma. I here call upon the hardworking Minister of Police, just like the Minister of Justice and Correctional Services, to work together and to bring the culprits to book. Those who want to destroy our country network infrastructure, those who want to destroy our country's telecommunication and infrastructure. We must at all times guard against wrongful activities in a big scale. Wrongful activities that happen in a big scale. Then 10.111 proactivity scale must be upgraded. In the past, before the former Minister of Police, in fact, the former Commissioner of Police, Jackie Silevi, the late Jackie Silevi, when you phoned 10.111, is like a tip-off. You want to, if you want to remain anonymous, you'll be anonymous. It is your call. And if you want to be known to 10.111 only, you'll be known, and so that you can be compensated for that tip-off. There was a budget for that. Silevi changed some of the things with regard to reporting on 10.111. They even removed telephone booths which were found and seen in the communities. Even in prisons, these telephone booths were removed. Maybe one of the reasons as well, it was because of vandalism. People will break into those booths and steal coins from them. I here call upon the Minister of Telecommunication and Minister of Police to bring back those telephone booths, and must be installed at the garages and also at the entrances of police stations. We must bring back law and order in our country, because there are those people who are committing crimes and that they are illegal among themselves because of their illegal activities. They are nowhere to be traced or found. And I hereby call the Minister of Home Affairs to take down all names and particulars of foreign nationals through the operation and assistance of all the law enforcement agencies, so that we can know where is everyone in the country, whether you are illegal or legal. It is a shame that some of us now are even scared to go to Johannesburg CBD, because you don't know what next will happen. Going back to courts, we must be able to draw the difference between the AKA and TIPS murder case and the Senzo murder case. In the former, the prosecution is still allowed to investigate because the matter is not yet set for trial. Even when they are busy with bail application now, they are allowed to investigate. I tended to differ with the prosecution in that case when they said it's a well-known fact that a matter is being investigated until judgment is made. Unless he meant to say a matter is being investigated until even the bail application judgment is made and the matter is set down for trial. You cannot continue investigating whilst you have set the matter down for trial, while you are in the middle of the trial, but you still investigate. It will render the trial unfair, because the most important thing before the trial must proceed, the defense must be provided all documents related to the matter so that proper instructions can be taken from the clients. So, in the matter of Senzo Murder Trial, the defense teams are well within their rights, and they have adhered to my advices and calls to object to the tactics by the state. For now, let me try and go through your questions, if you have any questions. MFMCBD. What can we do about Ratha's behavior in that court and justice for Senzo Murder Trial? Remember, ladies and gentlemen, you must be aware that the Honourable Court works based on the rules of the proceedings according to the civil procedure. Okay? And the Honourable Court is guided by the moves from the state. Because at all times, the Honourable Court, on the face of it, prima facie so, doesn't know the case the state has against the accused until evidence is presented to the Honourable Court. And the Honourable Court expects the state to be honest at all times. And whether the state is honest or dishonest, the fact of the matter is, if the state is misleading the Honourable Court, then the defense is allowed to bring it to the attention of the Honourable Court. If you can recall, in the bail application of Ntanzi, the state misled the bail application court to say they are busy investigating the matter. So if the state is saying they're not investigating the matter, then why they have to make such submissions on their affidavit opposing bail? On another token, it means that the state misled the trial court to say they are ready for trial. Because you cannot say we are ready for trial, and whilst the trial is ongoing, you are busy conducting investigations, and shabby ones for that matter. Look at the issue raised by Advocate Mugwemozulu to say the 205 shows issues of KZN taxi killings as alleged. And they got nothing to do with this matter before Honourable Judge Mokwatleng. So I've seen and I heard of a petition to the NDPP, the NPA. I think that's a good move. That's where problems started, from the NPA side, and that's where the problems must be addressed. So if the state didn't do Shady investigations, we shouldn't have been here with these issues. MFM CBD, I hope that you hear my point. Skills DJ Munisi failed the defense, hosted, contradict himself. I can't say that he failed the defense, but I can only say that he made a wrong judgment, and he can still fix it. He can still fix it during heads of arguments, or he can even fix it anytime before heads of arguments to say, Honourable Court, I retract my apology. And in fact, host did mention that, especially when Balwe is going to present that, because Balwe is trying to show to the court that there was communications amongst the accused. So in that way, the Munisi can come in from that angle and to say even the state is trying to show that there was communication amongst the accused. The fact of the matter is Ho's testimony contradicted the testimony of Steyn. Therefore, Ho's also contradicted himself. He did say there was communication amongst 5 accused. Therefore, the testimony of Steyn must be noted with a caution by the Honourable Court. And importantly so, also the issue of not calling Steyn must also be raising eyebrows to the Honourable Court, because it can't be that Steyn is on pension, then he cannot be brought to court, because there are so many people who were brought to court in this matter whilst they were on pension. Mulifi Mukatla, what do you make of Ratha winking at the witness? He did that to that lady who took swabs of Ntanzi. Mulifi, if any kind of such things happen in the court, and it is the duty of the authorities who oversee the presiding officers to make a decision and to inquire from the presiding officers what was the purpose and why the presiding officer must embark on that conduct, because they are also governed by their rules and ethics and the manner how they conduct themselves in court proceedings. And I bet I might have forgotten that the proceedings are live streamed. So it is in the hands of people like the Honourable Judge President, Honourable Deputy Judge President, and the JSC. Even the Chief Justice can also look into that, because they will inquire from him first. What do you make of this? What happened for you to do that? That's only I can say. Mulifi. Emma Seko, Rafa must go, please. Procedurally, if you are a defense team, you are not happy with the presiding officer, you take instructions from the clients to instruct you to make an application for the presiding officer to recuse himself or herself. And if you are not happy with some of the way in which the presiding officer conduct the proceedings, then you can there and then stop the proceedings and make an application for review of the whole proceedings. Remember, if you make an application for the presiding officer to be recused, it will be heard by the same presiding officer before it will go to another court. In the event that they are not successful with your application before the same presiding officer, you can either take the matter on appeal for the ruling of that presiding officer not to recuse themselves. MFMCBD, Johannesburg is beyond the wait. Dirtiness because of our leaders who are welcoming everyone to our country, who coming to vandalize cause they have nothing they doing in this country. MFMCBD, I'd like to differ with you in this instance. It is not upon our leaders only. You are also a leader, okay? If you see wrongdoings, report them. Remember, it's an offense to abet a criminal. It's an offense to keep quiet when you see someone committing a crime. It is an offense to shelter a criminal. When I say a criminal, I also include illegal immigrants because they are unlawful in the country. And those who are unlawful, they're supposed to be tracked and registered, and they must be known where they are. Okay? There are those good people who are coming from other countries into our country. And there are also those bad people. Those bad people, they commit intentional crimes. They commit cross-border crimes. They run away from their respective countries because of crimes they committed there. And because that crime is the only thing they know, wherever they go, they commit a crime. So it is the duty of the public as well to be aware and careful. Do things within the framework of the law and report all criminal activities. Finally, on this point, I can say the government of the day, because when you say our leaders will become specific, you cannot blame few people. Even the opposition, the government of the day, those who are in parliament, even the opposition, if they don't put laws in place to try and combat these criminal activities, they are also to blame, because once people enters a country and there is no means to stop illegal entrance in the country, then the authorities, they are also to blame. They must also work as a team. They must not compete with each other to say, I will do better than you. They must work, come up with ideas to stop any kind of illegal activity because being illegal immigrant is an illegal activity, it's a crime. Okay, ladies and gentlemen. And it also boils down to the point that whereby people are being employed, being illegal, and are being paid minute wages or salaries, and they try to complement those wages or salaries by committing crimes. The people who employ them as well must be held accountable. They must be regarded as accessories after the effect. They are accessories after the fact in that these people who come into the country illegally, then when they have entered the country, they employ them to suppress people who are legal in the country and the original citizens of a particular country. And they cause what? Tensions in the communities. It is the duty of government departments to work together. Department of Home Affairs, South African Police Services, Department of Justice and Correctional Services, Border Management, and the Labor Department. They must sit down and have a strategy to combat this kind of activities, including the Department of Enterprises and small businesses as well. Because these other people who come out of outside the country, they enter the country legally or illegally, so they open businesses. After they open businesses, then they employ some of illegal people. In so doing, it takes the opportunity of legal people or citizens to get job opportunities. They limit their chances and they cause tensions in the communities. They divide the communities. Many things will show their ugly face, ladies and gentlemen, especially this month. In the year of elections, many things, ugly things come up, manifest themselves to cause chaos and to infiltrate a country. Octavia Ntombo Zodwa Chabalala Habayo Rapa and Baloy must leave the justice system too. Ladies and gentlemen, Octavia, if you look at these things, in actual fact, the presiding officers are not supposed to be part of the justice system. Presiding officers are supposed to be and are meant to be independent. And the issues of presiding officers are dealt with by the JSC or Magistrates Commission. As for Baloy, the issue of prosecutors are dealt with through the NPA, and if a prosecutor is an advocate, it can also be taken up with the LPC or their respective bars. Hence, I commend those people who made a petition to the NPA. Because I'm of the view that this present prosecution team doesn't have title to prosecute. They are conflicted in this matter, and they should have removed a long time ago, even if during the first trial of before Honourable Judge Maumela, and the NDPP should have acted before even this trial started de novo. Sorry for that, because I've realized that the NDPP on this matter is mum, and her silence is deafening on us with regard to the conduct of the prosecution team in this Senzo Murder Trial. Mpikiseni Mkize. Yes, I think I gave the same answer with regard to Octavia. I hear you. Sherere Fosha, Justice for Mayor, please. Free Danzi and Muzuko Kelela. Umuzu to appeal. Thank you. Titi to open our eyes as the community. You are welcome. And if someone is of the opinion, especially the defense, that they want to make an application for review or appeal with regard to the decision of the Honourable Court, is welcome to do so, because we work within the framework of the law. We follow the procedure. That's why we have criminal procedure and civil procedure. And we have the constitution. We are living in the constitutional democracy. If you are not happy with something, you approach the courts for a ruling or for clarity, just like what the IEC is doing in the Constitutional Court. So that's the process. If someone is not happy with the decision of the court, you either review, appeal, resign, or vary. The purpose of us having courts, ladies and gentlemen, is to avoid people taking the law into their own hands. For example, if you think a particular decision is unreasonable against you by a particular authority, you are allowed to approach the courts to seek clarity. H2K, thank you. Hello, Andiswa Mjikwa. Sterere. Hi, hello, Titi. Thank you so much. You're welcome. Berhat Dindi. Yeah, Titi Tombani. No, not Tombani. It's Titi Tobani. Esobane. Because you see, Berhat Katindi, the name is a brand. Each and everyone's name is a brand. And I always correct people when they misspell my names. I don't take offense, but I always correct them. I hope you don't take offense when I correct you. Thank you. Peggy Sibia, the state literally misled the court when they told the court that accused number 2, Ntanzi, was arrested for Nongoma case docket, but they refused to provide the docket in court GT. You see, legal practitioners, they don't hesitate to call a spade a spade. Like what Honourable Advocate Mushololo did, and I commend her for that. She did a good job to put it clear, straightforward, without hesitation, that the state is dishonest. Doesn't mean if you are an officer of the court, when you are dishonest, you must be afraid to say it because you are the officer of the court and you cannot be dishonest. The state was dishonest from the onset when 2 dockets were presented to the state. The first being 375, they set it aside and looked at 636. The fact that they read the statements of the investigating officer, Kininda, whereby a particular name of Ms. Keke was mentioned, but the state could not take a decision on that. The fact that the state says no, they are awaiting the outcome of this matter to make a decision on 375. They are waiting for the court to make credibility findings against the witnesses who were in the house, but they are not calling all of them. How will they make the Honourable Court make credibility findings against those who are not called? The prosecution is dishonest in the sense that why they decided not to call Ms. KK. and they want the defense to call Ms. KK, pushing the defense to open their case. It is the duty of the Honourable Court to balance the ratio to say the Honourable Court is going to call Ms. KK before the defense case, and as the court witness could come and clarify certain issues, why her name is popping up on the statements of the police officers. This prosecution team is being dishonest in the sense that why this matter was in Plumsbridge and then it had to go to Johannesburg area. However, it was moved to to Pretoria area without a reason. And it will leave the public to speculate in that the both prosecution team members in 636 were working in the East Rand and got promoted to the national office in Pretoria. Hence, they moved the case to their side. Mahlomola Leboho, advocate, please add Senzo Murder in your renaming the title of this and other videos so that YouTube algorithm gets you more views. Okay, thank you, Mahlomola. That's a good advice. But remember, I don't want to be like I'm only dealing with the Senzo Murder Trial, but I appreciate your suggestion. We'll consider that. The algorithm, ladies and gentlemen, you also need to send us super thanks, hit subscription buttons, notification buttons, likes, and once this live stream has been uploaded, send your comments or questions and clarity-seeking statements, then we'll respond. Thank you so much, Mahlomola. I appreciate. Smangele Zaza, hi, how are you? Happy weekend to you too. Gift Nyati. That is a bad habit from a judge to weak an eye to a witness. It makes him to be suspicious for him to run this case. It shows that there's many wrongdoings happening behind closed doors. I hear you, Gift. As I said before, the people who oversee judges, their supervisors, if such incident is brought to their attention, they'll embark on an investigation, and they will also inquire from the said presiding officer to hear their side of the story, and including the Chief Justice or the JSC, they will look over that issue and they will want to get the reasoning behind such incident and why it happened, if indeed it did happen, ladies and gentlemen. Remember, we are living in a constitutional democracy. You cannot just take an action against a person without hearing their side of story. Thank you, everyone. I'm actually attorney, not advocate. David McCartney. I ask for all the legal minds to assist the defense in Murder Trial to expose the framing of 5 accused. Baloy and shenanigans. Let's see the culprits in jail. I think we must all agree that up to so far, the defense has awakened. And Advocate Mgomezulu followed my instructions properly and my advices concerning the issues. I think now they are on the right track. And it is unprofessional for other legal practitioners to go to impose on legal practitioners on a matter. You just suggest to them, and if they accept your suggestion, good enough. If they don't, fair enough. It is up to them to also seek advice and opinions. And as for Baloyi, I'll submit that the whole problem started on the NPA side. All the problems start with the NPA. The Honourable Judge, when he goes to court, doesn't have a clue at all what's happening on the matter until the Honourable Judge supposed to as well, not to have a clue on the face of it, on everything what's happening and what is the state is bringing, until such evidence is let into on record. The evidence is let into the record, and the Honourable Court is appraised. So the whole shenanigans are at the doorstep of the prosecution. Crash, good day, Titi. Wash, umkhukhu, residence. Good morning, brother Titi, watching from Australia. Nete, thank you, you're welcome. Please send us those super thanks. Nete, why then are they continuing if they are conflicted? This is a mess. I agree with you, but remember the reason why they are continuing, because they cannot see that themselves, they cannot see that they are conflicted. The only time if they can see that they are conflicted is when such an application is made and accepted by the court. Just like in the matter of Jacob Zuma, when he brought an application by Billy Downer. Okay? It is such a situation. We're not saying they don't have the right of appearance in the High Court. We're not saying they're not having a title to be prosecutors. When we say they don't have a title to prosecute, it means that they are conflicted, and they might be allegedly having some ulterior motives on the matter. Thank you, Nite. I hope you understand my point. Thank you, Sterere. Thomas Mahlangu, good afternoon, Titi. Hi, good afternoon. Smagele Dladla, please, God, help us to remove. As I said, ladies and gentlemen, applications are made in Honourable Court if you have an issue and you want the court to deal with the issue. For example, an application for a presiding officer to recuse themselves is made before such presiding officer. And if you are not happy with the judgment of that presiding officer, then you can take the matter on review. And as for the prosecution, the defense can also make an application for the prosecution to be recused from the matter because of they lack title to prosecute, in that they are conflicted. Vuyo Manent, do you think judge is fit to adjudicate or preside over this case? Any comment about him? Ladies and gentlemen, again, I'm of the view that a presiding officer is being appointed as a presiding officer on the matter because he is a presiding officer. Excuse me, and other things that they might consider as well is the experience. You must know that he is a retired presiding officer. And if someone is not happy about a presiding officer, an application must be made and facts be ventilated in court. You must put forward the reasons why you say so in that application. And one in other case, perhaps, I'm not undermining anyone here, but I think one in other is exposing. I don't understand that one, because presiding officers are not meant to expose each other. A presiding officer deals with their own case as it comes, and the other is the same way. However, a presiding officer in a lower court cannot cite a matter in a higher court before that matter can be made a precedent or before judgment can be handed down on that matter in the higher court. Lani Nkosi. The real word for dishonest is lying. So Advocate Mshola used the correct word. Yes, Advocate Mshola, because as I did say before, you don't say that in court. You don't say someone is lying. Okay? And even the witnesses, when they are testifying, as a defense team or a legal practitioner, you cannot say a witness is lying. You rather say the witness is dishonest or the witness is misleading. Zatal vote Zikali, with the evidence provided to you, do you honestly think that the 5 individuals are guilty and has the state provided the proper evidence? You see, I cannot make judgment, ladies and gentlemen, at this stage because the matter is before the Honourable Court. We normally deal with things that are already dealt with in court, which are in the public eye. Whether the 5 accused are guilty or not, we leave that in the hands of the court. Sorry for that. And the Honourable Court will look at all the evidence to make a ruling, and a just ruling. And it is the duty of the defense teams to protect their clients. The defense also will submit their own versions or evidence to disprove the state case. And remember, the court will also look at inconsistencies and contradictions in the state case before it comes to a just ruling. So the legal representatives don't come up with a ruling. They present counter arguments and evidence, and they poke holes in the state case. It is the state that must prove its case beyond reasonable doubt. But however, if a reasonable person sees that no, this state case is full of and is riddled with contradictions and inconsistencies, how can a matter go into the state way? Thank you, Thomas Mahlangu. Yes, tell them to like, please, ladies and gentlemen. Let's like, give us thumbs up, and send us super thanks. In the meantime, in 2 minutes' time, we'll take a break because we're going to go more than an hour, and we will take 5 minutes break and come up with those comments, questions, or clarity-seeking statements. We'll also revert. Yeah. All right. Please press the 3 dots on the right of the video and press the like thumb and send the super thanks. Pamela Osken. Good day, all. All we need is justice for Senzo Murder and expose the wrongdoing. Of course, 100%. We need justice, and justice must be ventilated, and the judgment must follow the evidence and what is presented before the Honourable Court. Morning Star Whip. If there was an intention to request for a warrant of arrest for K, why are not going ahead with that request still? Yes, that is the prerogative of the state. When I say state, ladies and gentlemen, I mean the NPA. It is in the hands of the NPA who must make a calling, they must make a call, because they are dominators, elitists. Mahlambe Shabango, what's up with you and the judge? There's nothing up between me and the judge, and there's nothing down between me and the judge. We are level. We're just normal. I don't have issues with anyone. I look things as they are, and I comment based on what transpired in court and not what is going to transpire. Mahlape Shamango, if that is meant for me. But honestly, this honorable judge before the court, I don't have a beef with him. We don't know each other on a personal level. And I'm yet to appear before him with regard to that motion application to compel the state to charge Ms. KK. And that's all I can say. Yeah, these questions are coming thick and fast. I appreciate that. You said, Zikari, you said with evidence since the previous trial, what was disclosed to you? Did it link to the 2014 incident and the murder of Senzo? Because so far we haven't had evidence linking them. Wow. T-Style, Volume 1, Zikari. That's a good question. I mean, come on, man. You can make up your mind. You see, the same tactics applied by the state now, they also applied to them in the first trial. They gave us exhibits, statements, trip by trip, okay? And in piecemeal. Even these 205s, we didn't have them, okay? Including the so-called confessions, statements were not there. So, another thing I can say, as the defense teams, we work on instructions from the clients. And there is attorney-client privilege. If the client instructs me that they are pleading not guilty, then I can't question them. I must submit that to the Honourable Court. That's all I can say, Sikali. Sorry for that. Who's this guy? Sly. At what stage should then that motion be presented to this Mewa court case judge? No, I'm not a judge. Sly. It depends, because to go to court you need funds. It's a motion proceeding. You need to upload documents onto the court online, and you need to serve all the parties consent, and prepare research and go to court. And also to appear in court, it needs resources in the form of finances. There are appearance fees. In total, to go to that to take this motion to court, it can cost 20,000 rand, including the preparations, payments of overheads, and drafting, and also going to court. And I don't have such funds, ladies and gentlemen, and it cannot be upon one person to embark on that. Hence the purpose I came up with this platform as well, to say whatever we're doing here, we must try to raise funds. Hence I'm also asking for super thanks from everyone, and know that even if this platform, this channel grow big, if it happens that it grows big, all funds raised in this channel will go a long way to also help the indigent and poor communities, and in trying to address some of the wrong things happening in the communities. For example, storage, overspills, and all other wrong things happening in our communities. Olani Nkosi, Mr. Titi, DNA evidence was debated. The word inconclusive came with the judge after the expert finished. This word is now being used to cast out the DNA. Are judges allowed to introduce such words? It's issue of interpretation, okay? And remember, judges cannot just be referees. They must ask questions and seek clarity. So it boils down to interpretation of statutes course. If you remember that course in when you study law, we had a course called interpretation of statutes. Interpretation. There is a minor interpretation of a word and a broad interpretation of the word. So in this instance, the word inconclusive, it can be interpreted broadly. Okay? You say inconclusive. Ladies and gentlemen, it can also mean that whatever was established on the DNA doesn't give them idea or doesn't say the accused were at the scene. So it excludes the accused. What's the opposite of the word inconclusive? Inconclusive can also mean that because of lack of certain levels or ticks, it shows that there's no sign demonstrating that the accused were at the scene. Because that's the threshold of the DNA test. It must meet all the requirements. It must tick all the boxes. And that's how you prove your case beyond reasonable doubt, ladies and gentlemen. Hence, I even argued the fact that why the residue was not taken from those people who were in the house when Musia arrived. The explanation by Mangena, it doesn't hold water to say anyway they were the scene. But why they didn't take the residue? Because if they take the residue, it will always show difference of percentage among those people. In some, it might show 100%. In some, it might show 50% or 90%. But now, if it shows 100% on a particular person who was in the house, that person must be treated as a person of interest in the state case. Obvious, what makes the state case even more weak is that the accused were not arrested at the scene. And they could not even take a residue on the accused because this crime they were only arrested years later after the alleged commission of the crime. The investigating officer mentions a different type of a firearm, but the state alleged another different firearm. Xolani Nkosi, I hope you are happy. Superior Goodman's some higher. If you know the volume of a body language, you can then it's everywhere in someone's table. Presiding officer is not make sure. Oh man, good man. Do you know what evidence Nkomezulu has regarding what he put to the investigating officer? Remember, ladies and gentlemen, whatever the evidence the defense team can have, it's not the duty of the defense team to prove they're innocent beyond a reasonable doubt. It's the duty of the defense to poke holes on the state case, and the state must at all times prove its case beyond reasonable doubt. Whatever the evidence Mgomezulu is having, it will just complement the defense and case, and that's it. Olani Nkosi, what is the status of the DA currently? Unfortunately, I cannot keep that in my mind, but all the boxes were not ticked. That's what I can say. Olani Nkosi, yeah, you see, you also explain it the way you understand it. Inconclusive mean that not enough, but there is something. I agree with you. That's what the court even said. But remember, inclusive mean not enough, but there is something. Then this means that the state is not proving its case beyond reasonable doubt. Okay? So if the case, this case, you understand my point. If it means not enough, then it's not beyond reasonable doubt. It's not because doubt can be casted on that. In theory, analysis inconclusive typically means that the results obtained from the analysis do not provide clear or definitive evidence to support a particular conclusion. I agree with you again. Then it means that the state will not and cannot or could not prove its case beyond reasonable doubt based on the DNA. The principle of proving the case beyond reasonable doubt, ladies and gentlemen. Dimakazo Dlamini, thank you so much, Dimakazo. Thank you, everyone. Please follow Dimakazo. Thank you. Please follow Dimakazo. David McCartini, why Intans is not getting bail? No previous offenses. That's a good question. We did make a bail application and it was dismissed. And the bail was denied based on the fact that the reasons given by the court. And in one of these affidavit by the state alleged that they are still investigating the matter. This could happen for several reasons. Insufficient data, the sample collected might be too small or degraded, making it difficult to obtain reliable results. 100%, Silai. It means the state cannot rely on that to prove its case beyond reasonable doubt. Ambiguous results. Sometimes the analysis might produce results that are difficult to interpret and on that show inconsistencies. Thank you. Same point I'm saying. It cannot help the state to prove its case beyond reasonable doubt. Complexity of the sample. In some cases, the DNA sample might contain a mixture of genetic material from multiple individuals, make it challenging to determine specific details. I thank you. State cannot rely on that. Olani Nkosi, thanks, Mr. Titi, well explained. Thank you. You're welcome. Sly, technical issues, errors or limitations in the testing process could lead to inconclusive results. Yes. Then they don't meet the test of beyond reasonable doubt. Like when DNA analysis is inconclusive, it means that further investigation or additional testing may be necessary to reach a more definitive conclusion. Yes. Did they do that? No. David McCartin, DJP, the governor presented to the dishonest bail application for Ntanzi 1819 bail and on the lines of advocate Babu in the how to Ntanzi's situation to him get bail now. He can make an appeal. And if he doesn't want to make an appeal, he can also make bail on new facts. Zukali, I understand Mr. Titi. Lastly, do you think that the current trial is fair? I mean, if they need to prove it beyond reasonable doubt, according to what you could say, the defense needs to do. What could you say the defense needs to do to win? And the defense is doing well up to so far since that address of Ngomezulu mentioning other people from the house. Up to so far, the defense has poked holes in the state case, and it is the duty of the state to prove its case beyond a reasonable doubt. With regard to the issue of fair, I mean, the trial, it flows according to rules of procedure in terms of the CPA and the law of evidence. And that's all I can say. It will be up to the Honourable Judge to make a ruling on the matter at the end of the day, whether the trial was fair or unfair. But it's very important that if the defense feels that there is unfairness, they must raise it with the Honourable Court. However, in the event that the defense overlook that unfairness, the court must also raise it with the state. Remember, most of the time, the fairness of the trial, it will start at the doorstep of the state on how they present their case and on how they conduct the trial, and including the tactics, whether they are playing their cards close to their chest. Thank you, ladies and gentlemen. Can I take 3 minutes break, please? Send the super thanks like Madlamini did. I'll be back in 3 minutes time. I'm back, ladies and gentlemen. I think we are left with 20 minutes. Let's push it. Send those likes and super thanks. In this 20 minutes, I also like us to look at the issue of the IEC going to the Constitutional Court to seek clarity. Ladies and gentlemen, it is upon their rights to go to the Constitutional Court to seek clarity on certain issues. But in so exercising their rights, they must not violate the rights of others and not interrupt the election timetable or processes in their own words. Or everyone must stick to the timetable. However, if they're not ready for elections, they must make it clear and inform the number one that they're not ready for elections and they seek postponement. Because you cannot appeal a matter from a lower court to a higher court before you start in the lower court. Okay, ladies and gentlemen. So basically, the IEC was tactical. They're not saying they're appealing. They're saying they're seeking clarity. If they're appealing, then it means they must start in the electoral court to make an application for leave to appeal. And the electoral court must make a ruling whether they grant them leave to appeal or not. And if the electoral court doesn't grant them leave to appeal, then how they should have went to the Constitutional Court. Hence, they are saying they are seeking clarity on the issue. Therefore, if they are seeking clarity, it's not an appeal, and they are entitled to be heard by the Constitutional Court, meaning the ruling in the Electoral Court stands. I apologize for that, ladies and gentlemen. After this live stream, I must go and cut my hair. Yeah, it's becoming a forest now. So it seems as if there are so many matters into these elections. These elections are contested even out in the courts now. It's becoming really, really tense. And even the international community is watching with interest. For example, it was also my concern regarding to the issue of one political party that went to a certain government, foreign government, to seek assistance. Can you imagine, ladies and gentlemen, to seek assistance with regard to elections in a sovereign state of the Republic of South Africa? We don't know what that political party provided to that foreign government. And that can amount to a crime, ladies and gentlemen. A crime of high treason against that political party and its leaders. For example, it also now emerged that this particular country that was approached by this particular, this particular country that was approached by this particular party, it has come up with intelligence reports on 4 top South African political parties, and they are in position of that report. Why? Why they must embark on that? Are they interfering with the elections of the Republic of South Africa? They are interfering with the sovereignty of the state. And that will amount to violation of the international law by that foreign state. We don't have a problem if non-governmental organizations from all over the world, from the United Nations, African Union, and any other non-governmental organizations from any other particular country, to come to South Africa and observe the elections. But they must not have influence and sway the votes. I hope you understand me on that one, ladies and gentlemen. Let me again go through your questions or statements of seeking clarity. I can see Kanyesile Tulu ask, do you know if the information that was held by Brigadier Ndlovu has been found or not? I'm not sure, but the point is, whether found or not, the state must pass the test of Law of Evidence Amendment Act. If there was an affidavit by Ndlovu, Brigadier Ndlovu, and Brigadier Ndlovu has passed on, the state needs to seek consent from the defense whether to use that affidavit or not. And if the defense objects to the use of that affidavit of Brigadier Ndlovu, then the state must make an application to the Honourable Court. And the Honourable Court will also hear counter submissions by the defense. There and then, the Honourable Court will make a judgment on whether that affidavit can be used or not in terms of the Law of Evidence Amendment Act. Same goes to the issue of House and Steyn, ladies and gentlemen. If House is using Steyn's affidavit, the defense should have objected and insist that they call Steyn. More especially, Steyn is still alive. And if the defense object, then the state was supposed to make an application before the Honourable Court and give reasons why Steyn cannot be brought to court, but not the fact that Steyn is on pension. No, that's not an excuse good enough. Okay? Princess Mbuyele, can you hear me? Maybe it's a network infrastructure issues, but I'm back. So what I'm saying is, to say that Steyn is on pension is not good enough. There are several witnesses that they were on pension. They were brought by the state to testify. Maybe there is something more than to meet the eye behind the issue of Steyn not wanting to come to court. If you can recall, in his testimony, Steyn only maintained that there was alleged communication between accused 5 and Ms. KK. And then Advocate Mshololo gave a reasonable explanation to say it's not first time she represent accused number 5 when the issue of her communication with the accused number 5 came up as well. The communication between Msholo and accused 5. And then she came with a reasonable explanation to say it's not first time she represent accused number 5 as well. And then now, suddenly there is a change of statements to say, in fact, there was communication amongst all the accused pertaining to be stains of David, of which House wanted to amend it viva voce, and it was unacceptable. And the defense objected correctly so. How do you amend an affidavit which is not yours? That's where I respectfully submit that the court made an error in that regard, because you cannot amend an affidavit which was not done by you, but you can make your own supporting affidavit or supplementary affidavit, not to amend the affidavit that was not done by you. And amending it viva voce, it also creates problems. And it was going to, in a certain extent, count in favor of the defense to raise the issue of contradictions and inconsistencies of the evidence by House. However, Balwe will also say, no, in actual fact, this affidavit was not done by House, but by Steyn. So then bring Steyn. Bring Steyn. Why can't you bring Steyn back? You want us to draw inference. Okay. The inference that can be drawn is that Steyn could not agree to the change of his affidavit to the effect that there was also communication between accused. Because in his initial testimony, he never mentioned any communication between the accused. You see, that's the danger of hearing evidence in piecemeal, because some people will consult with a witness on a particular point, whilst such witness is still under oath. That's the danger of consulting with a witness who is still under oath, who has not yet finished testifying under oath. That's why the Honourable Courts, most of reasonable Honourable Courts, when the matter adjourns, they'll always warn the witnesses not to talk to anyone pertaining to the matter, because such witness is still under oath. Princess Ngubuyile manje awusakhulumi. Ladies and gentlemen, where are the super thanks? I'm trying to check here. Kindly send, please. Send the super thanks. It promotes the channel so that it can grow. Remember, this is our channel. It's not one person's channel. By sending super thanks, you also promote the algorithm. Because, ladies and gentlemen, you must have realized that this platform algorithm is very intense. When you reach a particular number of views, when you reach 40, let's say 40,000 views, okay? After that, these views somehow suddenly they keep on going down. Even you are still going live. Even you are still going live, but they keep on going down. So the only way to grow the algorithm is to send super thanks as well, which will also grow the channel. I think on the issue of Mr. 50 years of experience. Oh, what's your name again? Month B. Smith. I hear you, but please let's still maintain community guidelines and show respect to each other, even we may differ with how we deal with things. Let us not play the player, but play the ball. And experience sometimes comes handy depending on how you utilize it. Some people, they might have experience in something and they use that experience to try to outbeat certain processes or to outlast the system because of the fact that they have experience. Okay? But we must not take it away, ladies and gentlemen, that the case of R versus Hepworth, it came up with the Honourable Court, and it helps a lot when we're looking at the issues. And it poses an indictment on the Honourable Court to always keep in mind that case. Okay, Pamela, welcome. Digoliza SKK, thank you. Thank you, ladies and gentlemen. If you can remember, I raised the issue of the IEC going to the Constitutional Court. You know, I needed to get hold of the court papers of the IEC to the Constitutional Court. I want to look at them and to see exactly the depth of their application to the Honorable Constitutional Court. And it is true and correct that, with due respect to the Chief Justice, thank you, Crash, that the Chief Justice must not sit in that matter that is brought by the IEC. As you know, the originality of that issue that made the IEC and MKP go to the Electoral Court. And now the IEC is going to the Constitutional Court. Even if the IEC doesn't cite the MKP in their Constitutional Court papers, it's still okay because the IEC is not litigating against anyone. It's not litigating against the MKP or the ruling of the Electoral Court. The IEC only goes to the Constitutional Court to seek clarity. However, in practice, since the IEC has interest in the matter, I apologize, since the MKP has interest in the matter, including J.G. Zuma, the IEC might cite MKP in its court papers. And or even if the MKP has not been cited by the IEC in the Constitutional Court papers, the MKP can approach the court and make an application to be joined in the proceedings, or be the friend of the court. Even you and me, an ordinary person, can make an application to the Constitutional Court to be the friend of the court. And firstly, before the matter is fully ventilated, the Honourable Court will firstly deal with the issue of direct access. And after dealing with the issue of direct access, whether it grants it to the IEC or not, and it will also deal with the issue of agency. The IEC must demonstrate why it says the matter is urgent. The IEC must not deal with the facts of the matter when addressing the issue of urgency. So it goes to any other urgent application someone can make. When you make an urgent application, I'm doing this, ladies and gentlemen, because the purpose of this channel is to assist each other and empower each other on how certain procedures work in courts. Even myself, if someone can come up with something on this platform and teach me, it is acceptable, and advise me on how things go. Most importantly, it is acceptable. Just like what Kali was doing with regard to the issue of the DNA. Because based on what he said, he somehow or she somehow empowered all of us. So I'm saying, when you go to court on urgent basis, you must firstly deal with the issue of urgency, why you say the matter is urgent. And when you deal with the issue of urgency, you don't deal with the facts of the matter. You need to show the court the urgency and the fact that there's no other way you can handle the matter. And if the matter is not dealt on urgent basis, what prejudice you are going to suffer as the applicant. I hope you understand me on that. Thank you so much. Let's pack it on this issue of agency. We will deal with it as time goes on in the future live streams. Before we wrap it up, let us go through again to statements, comments, and questions. Smith, with all due respect, but Mr. 50 years of experience here doesn't bring anything to the take with the experience. As I did say before, Smith, the Honourable Courts, when they deal with the matter, they are not supposed to have an idea what the state is presenting to the court until such evidence or testimony is led. And the Honourable Courts are guided by the law and case law precedents. And case law, you must know that it's not a must that a Honourable Court must follow what was said in another case. It's just it has just a persuasive influence, but it's not a must that the court must follow everything that was done in that other case that was held previously. Because I apologize for that, we are connecting because we have been on the platform for more than 1 hour, 30 minutes, hence it will cut now and then. Each and every case differs from another. Each case has its own facts and merits upon which decision must be made. Hence, I always maintain that each and every case that was decided, especially before 1994, must pass the constitutional muster, and it must not be inconsistent with the Constitution. There's the gentleman, Godwin Baloy. Godwin, respect. Godwin, where do I know you from, Godwin? Not Godfrey, man. Godwin. Yes, Godwin. Where do I know you from? Afternoon, I wanted to know if it is possible to produce new evidence while you are on a trial. It is not possible. As per State versus Chabalala. Go and read State versus Chabalala. It was just decided just after 94. It's starting the Chabalala with TSH. Okay. And the Constitution, Section 35. Because before the matter is set down for trial, the state must inform the Honourable Court that they have done with investigations and investigations are complete and the state is ready for trial. Then the defense will make an application for copies of the docket. Once copies of the docket and other contents are provided to the defense will sit down with their client and consult after going through the contents of the docket, advise, and take instructions. Then they will proceed the trial. However, in the event that the state keeps on bringing new evidence, it means the defense must stop as well. They must change the version now. They must go and take proper instructions again from the clients, which will render the trial unfair in the sense that the court will say no, but why you keep on chopping, changing your defense? They're doing so because it's the state that keep on bringing up new evidence, new exhibits, and new affidavits and witnesses. So the defense are also entitled to go and take further instructions. The Defense Counsel on Thursday, 2 May, they were like a pack of hyenas. We thank the teamwork. Smith, yo, Kumalo, Smogile Kumalo. Hi, Mr. Double T. This case, aku akusuyo ekabaloyo no rada ekasenzo ngokufa kwakhe. Okay, ukuthi kwenzekani uphi case 375, please. Baloyi no rada kwesekani basifuni ncasi 363 ngoba ngumaloyi. It's not 363, it's 636. And docket 375 was well introduced by the defense, especially by Advocate Mgomezulu, and it will remain an integral part of this matter of 636. Just like Baloyi, the state mentioned other cases that are outside 636 that are not related to 636 by also producing pictures of bags of monies and pictures of firearms, and of those pictures of names, words used in those pictures which are not related to 636. And they are inadmissible evidence. But they came up with them. So the defense are also within their own rights to produce docket 375, which is like a twin, same as a twin to 636. You cannot separate them because 375 emanates from 636 after certain statements gone missing in docket 636, and also after. And I would like to thank everyone for participating and being part of the live stream. And I'd like to say I appreciate. Let's grow the channel. All of us, let's give it super thanks. Hit the notification buttons for future purposes, and send us the super thanks to grow the channel. And let's keep up the good work by abiding by the community guidelines. And I'd like to say thank you. It's a wrap up. However, I'll go through all the other questions I didn't answer for now. In the event that we got cut, at least I did say thank you very much, and we'll hear from each other in the next coming live streams. Let me just finalize these other issues. And I was saying docket 375 and 636, they are like siamese twins. You cannot separate them. Docket 375 emanates from docket 636. And Smith, I don't think the judge did dismiss docket 375. The Honourable Judge just listened to the submissions of the state and said, okay, that's not the ruling, because the state told the Honourable Court that the docket 375 decision will be made after the Honourable Court has made credibility finding on 636 about those people in their house. And also the decision on those people in the house will be made by the NPA at the end of this 636. Literally, it's not dismissed, but we are saying, and we have been saying, even in the past, me and therefore, that it is a delaying tactic from the state. They must make a decision now, by yesterday, with regard to docket 375. If they cannot make a decision, then they must not prosecute it and issue a not prosecute certificate. Maybe someone like me might pursue private prosecution. But in order to pursue private prosecution, ladies and gentlemen, you must have deep pockets, because there is a deposit you must pay for you to proceed with private prosecution. Just like what happened in the matter of J. Zuma versus CM Ramaphosa on private prosecution issue. You only can proceed with private prosecution after you paid a certain deposit. It needs deep pockets, ladies and gentlemen. Nzunzo Sibia. What does that mean? There's those umojos. I don't know that umojo. Yes, Pamela, you're welcome. I think I'm done, ladies and gentlemen. I'll post a podcast. Okay. And if there's any other issues they need to be clarified, we'll take it from there. Good afternoon and have a blessed weekend. And I just want to put it very clear. Please don't misunderstand me. This channel is apolitical. This channel doesn't take sides. This channel, we deal with the issues as they come. We deal with the issues which are in the public domain. We deal with issues which are on record in court proceedings. Because once the proceedings are on a court record, they are of a public matter, especially in a live stream court proceedings. We cannot anticipate what will happen and deal with an issue before the issue has been dealt with in court. We are commenting on what happened in court. And based on what is presented on court, what is presented in court, we come with a reasonable expectation, a reasonable explanation, a reasonable summary from our side on what supposed to be. Okay? Even if when I dealt with the issue of the IEC, I am not becoming political. We are apolitical. The issue of IEC is no more about politics only, because it's also now before the Honourable Courts. Hence, I am commenting on that. Hence, I am dealing on that. It is in the public domain. Hence, I'm saying, after here, I'm going to look for the court papers of the IEC to the Constitutional Court. If anyone amongst us do have them, kindly send them to me by email or DM me. My email and the telephone numbers are there on the page of my platform. My email address is tobani22@gmail.com. Tobani with capital letter T. And my cell phone numbers are +27 international number 781396506. I thank you very much. Thank you. Enjoy. God bless.